Hello, I'm Warren Scheel. I'm a divorce attorney and mediator in Los Angeles. It's important to remember that in California we're a community property state, which means that with some exceptions, spouses are entitled to an equal division of community assets and debts. The major exception is if you have a prenuptial agreement that provides otherwise. What is community property and separate property? Community property is all property in California or out of state that is acquired during marriage through the efforts of either spouse or with community property funds. In figuring out whether a property is either separate or community property, the important thing to remember is not whose name a particular account is in or who earned the money, but whether it was acquired during the marriage. That's from the date of the marriage to the date of separation. For example, if one spouse works and invests his or her savings in an account during the marriage, then both spouses are entitled to 50% of those funds. Contrast this with the situation with separate property, generally defined as property that's either acquired prior to the marriage, property acquired after the date of separation, and the third major separate property category are inheritances which are received either during or after marriage. So for example, if you do receive an inheritance during the marriage and you wish to make sure that it remains separate property, it's always a good idea to keep it in a separate account and not to commingle it with community property funds. The allocation and characterization of assets and debts as either community or separate property is one of the main areas of litigation in divorce and family law. And it's one of the reasons why you may need the services of an experienced family law attorney. In this brief presentation, I'd like to address a few of the issues that come up repeatedly in divorce and family law cases. One, the date of separation. The date of separation can be critical because, as you recall, any property acquired prior to the date of separation is generally community property, and any property acquired after the date of separation is separate property. Number two, fiduciary duties and the duties to disclose. In California, there is quite a strict requirement to disclose all your assets and debts, and also any business opportunities and investment opportunities that arise either during the marriage or after the date of separation, but prior to the final judgment in the matter. This has become quite an issue in family law cases recently because of a case called Feldman. At our firm, when we advise clients, we emphasize the importance of disclosing all assets and debts and also business opportunities that arise. The other side of the coin, especially if you're representing the outspouse, is discovery. That's the process by which you seek financial information from the other spouse. If assets are concealed and not disclosed, we often advise the clients to seek the services of a forensic accountant, in addition to commencing formal discovery with the service of production demands, requests for admissions, interrogatories, service of subpoenas, and depositions. It's very important, critically important in this kind of situation, to hire an attorney and also a forensic accountant who has experience valuing businesses and the correct accreditations, but also an accountant who has credibility with the judge who is hearing your case. 4. Pensions. Now, after the family residence and family businesses, pensions are usually the most important and most valuable community property assets in a marriage. The non-employee spouse is entitled to at least 50% of any retirement plan that was earned during the marriage. Depending on the type of pension, we usually advise our clients to retain a separate pension specialist who prepares a qualified domestic relations order, or what is commonly known as a quadro, to split the pension. Number 5, your attorney should pay special attention to often overlooked assets such as tax refunds, frequent flyer miles, stock options, season tickets, and prepaid insurance. Also the cash value of life insurance policy and timeshares. 6. Tax consequences. Either your attorney or a tax advisor should advise you on the tax consequences of any settlement. Generally, the IRS code provides that transfers incident to a divorce are not taxable, but this doesn't take into account the later tax consequences of the sale of assets. It's therefore very important to consider the tax basis of any assets such as shares when you are deciding on their division. Otherwise, what may have seemed an equal division may turn out to be a very unequal division when you sell the shares and you get the capital gains tax bill. I find in many of the cases where there's a proposal on the table that the wife keeps the family residence and the husband keeps the family business, which by the way is not always the best idea if you're representing a wife. You should be aware that once there's been a transfer of the family residence to one of the spouses and that spouse then decides to sell the residence, they are only entitled to a $250,000 tax exemption for capital gains tax. I hope you found this information useful. If you require any more information, you can visit my website at lafamilylaw.com. Thank you for watching.